Good afternoon. Welcome to today's webinar, ADA lawsuits, why 95% of the more than 4,000 settled last year and what it means for your business. My name is Bethany Servin, and I work here in marketing at UsableNet. And I'm going to go ahead now and hand it off to our first speaker, Jason Taylor, for introductions.
Thanks, Bethany, and thanks everybody for taking some time out today. My role here at UsableNet has a number of hats. One of those is that I oversee the research that we do around tracking lawsuits. So all the data that you're going to see in the following slides is essentially compiled by our internal team that is looking for and tracking lawsuits across the United States in relation to web accessibility and mobile accessibility claims. I first want to bring in John to introduce himself. We try to do webinars around different subjects and trends that we've seen in those data that we collect. Today's one, we're going to sort of at a high level talk about why the majority of cases actually settle, and you don't see lots and lots of cases. But we'll get into that detail a little bit over the next 45 minutes and leave some time for questions. But John, maybe you could introduce yourself and your firm and where you specialize.
Sure. Thanks, Jason. And thanks to all of you for taking the time to be with us today. My name is John Egan. I'm a partner attorney at the law firm Seyfarth Shaw. I'm based in New York, and I'm one of 3 partners at the firm that focus exclusively on accessibility, the ADA, state and local disability access laws, regulations and requirements. I'm a litigator, but I'm also a counselor. I work with clients of all shapes and sizes on developing compliance programs, including increasingly on the complex and ever-changing area of web and digital accessibility. And so happy to be with all of you and with Usable here. Thank you.
Thanks, John. So just a quick recap of the agenda. We're going to start with some high-level statistics to sort of shape the conversation. John's going to talk about some of the real detail that he sees in his role that you just heard there in terms of actually trying these cases and supporting clients that have received client claims. He's going to talk about why the vast majority of those claims are settled out of court, and that you don't see a lot of case law being generated in this space, although you see lots and lots of actual cases. And then hopefully what we'll do is, give you some takeaways with regard to key components of strong defense, but also I think John and myself would talk about what type of activity you can do to significantly reduce receiving one of these claims, which is the let's say the best possible defense about a claim is not to receive one, and then we'll leave some time for Q&A. So starting with some of those big numbers, so we set the scene here in terms of the vast number of cases out there. In 2023, there was over 4,500 cases against digital properties, and what we mean by digital properties is primarily websites or mobile apps. Why we distinguish that is because John will talk about that he also gets involved in physical ADA. So what our resources do to generate and separate that out is we actually download every single lawsuit filed under the ADA. We read it to make sure to find out which ones where the subject matter is a claim against a digital property, not a physical property. And then we track those cases. This actually slide brings in a very interesting trend that we're seeing in 2023, and we're also seeing in 2024, and we can talk about. And that's that in 2018, for example, when we started, nearly all of these cases would have been filed in federal court, so across the 11 circuits federally. But we're increasingly seeing the use of local statutes, state-level statutes, to have cases filed, where almost a third in 2023 was filed in state court, and primarily in California and New York. And John will get into that in a little bit. But just to give you again, the reason why people like the Wall Street Journal and Forbes use our report is because we actually go into those state level courthouses, and we track all the cases in the most prominent states. And again, really to pull out which cases are aimed at a digital property, and we track those for trends. So, and the last point here, and as I open up to, you can see the trend over in our reports over the last 5 years, is we're just compiling the final numbers for 2024. There will be a link probably either in the follow-up or even in the notes right now for you to sign up to get that 2024 report when it's due out at the end of this year. So you'll get access to it. It's free access. You just have to sign up to get the report. We've been running this data for 5 years. There's some interesting components around trends, and we write blogs on this on a regular basis, so you can look back and see the trends. I think one thing that we want to call out is that these are only lawsuits that we track. So we only track federal and state lawsuits. We do not track the number of demand letters. And maybe actually, John, I can just bring you in briefly here to explain the difference between a lawsuit and a demand letter, and how many demand letters you feel are out there compared to lawsuits.
Yeah, it's a great question, right? So a lawsuit is the filing of a complaint in either federal or state court, where claims are asserted under the ADA, under Title III of the ADA, as well as any applicable state or local non-discrimination laws. A demand letter is essentially a threat to file a complaint. It may have a draft complaint attached to it, but that is where the law firm and the plaintiff, or the prospective plaintiff, the individual filing the claim with the disability, is going to say, I encountered these barriers. I'm asking for you to engage in early settlement negotiations to avoid the filing of a lawsuit through a complaint in court.
And it's a good distinction, and I just want to explain why we don't track demand letters. They are not public. Everything else, everything that we're tracking is public. So those lawsuits that we track at the federal level or the state level are public filed lawsuits. So we can track those, and that's why we don't track demand letters. In my estimate, demand letters are at least equal, or if not more, than the number of filed claims. I don't know if, John, you'd have a similar opinion or a different one.
Well, it's sort of anecdotal. We get a lot of them, and some of them, if they're not responded to, knowing the attorneys that send them, they almost certainly will mature into the filing of a claim, which some of our clients will not want to have happen. But on the other hand, there's also folks that will, send out a lot of letters, and maybe that demand letter won't mature into a claim, or at least not without a follow-up. So it's hard to know, but I would agree with you, Jason, that there's a lot of them for sure.
And that actually brings me, so all of these, we've got lawsuits that are happening, claims that are being filed federally. We've got claims that are being filed in the state, and we have demand letters. But I think John and I pretty much agree on the next slide, which is there's not a lot of difference in terms of the typical claim. Even a demand letter claim has the same sort of elements as the claim. As John said, a lot of demand letters are actually sent with the actual potential claim that they say they're going to file attached. So there's some things that we can pull out to give you an idea of what is typically in a claim or in a demand letter. And I would say that, there's two types of plaintiffs. Typically, and I would say 99% of what we see today is that the plaintiff has visual disabilities and uses assistive technology such as a screen reader. And that sets them up as the plaintiff that is bringing the claim against the inability to use a website or a mobile app. In a small number of cases, the plaintiff has hearing disabilities and are primarily worried about videos or targeting videos or other types of films, for example, that don't have captions. The main, let's say, the main claim is done through the inability to complete a task. Because they cannot complete a task in the same way that other users can, they are being discriminated against. So that's the unequal access component. There will also be some reference to the WCAGs, or the Web Content Accessibility Guidelines, essentially adding some bulk to the claim, I think, more than anything else, saying, hey, we found all of these things which don't comply with the WCAG, and John would go into detail to explain the WCAG guidelines do not exist in the ADA, but it's a way to build a picture of hey, this plaintiff couldn't complete a task. And we've also found that on your website, there's lots and lots of items which fail under the WCAG guidelines. They may list other features. In particular, we've seen a trend recently where they'll list features of cheap sort of accessibility widgets, which have been put on websites to try to solve the problem. But those widgets might be useful for some people with disabilities, but screen reader users do not like them. They typically interfere with their current technology that they use for screen reading. So they essentially get listed as another quote unquote barrier. Again, these are claims of barrier or unequal access. A lack of an accessibility statement helps create the assumption that the company is discriminating against people because they haven't actually set out their plan for accessibility. Again, this is not written in the law, but it's about creating a story and a claim that allows the plaintiff or the plaintiff firm to essentially establish that the website is not just the website's inaccessible, but the company that owns it isn't taking accessibility seriously. I think the last two are very legal, and I think they're ones I want John to talk about. The first one is, this isn't 4,000 individuals struggling for a while and going out and finding 4,000 lawyers. This is a very focused activity around a very focused set of plaintiffs who could be described in different ways. They will describe themselves as aggressive advocates around making sure that they can do things online that everybody else can do. They could be described in different ways by other people. And they are represented by a very focused group of law firms that are very used to making these types of claims. John, how does that work? How does that practically reflect itself? Maybe even do you have the same thing in the physical world as you do as the web, the digital world? Is it concentration like that too?
Yeah, it's a good question. You absolutely do have that concentration in the physical accessibility world. To answer the question, and I think for a number of audience members, it strikes you as unusual and suspect that you have such a small concentration of plaintiffs and plaintiffs' lawyers filing these cases. And I think you have to go back to really the purpose of the ADA and what it was intended to do and what it's actually doing. Okay, so the idea in many ways was that we're going to, as a country, we're going to empower individuals with disabilities to be their own attorney general. So it's not going to require that the individual with the disability contact a government official and say, I want you to investigate this business for having barriers, be they digital or physical. It's a question of empowering that individual then to go out into the world, and if they encounter issues, to do something about it. And what ADA Title III provides for is not damages, like I was harmed by this, but rather the ability for a court to enter what would be considered an injunction to tell the business to do something. And that do something would be remove the barrier. And there's a section of the ADA that says people with disabilities are not required to engage in, and I'm paraphrasing here, futile gestures, futile actions. So the individual with the disability when they file the ADA Title III claim, can challenge not only the barriers that they encountered, but the barriers that they would have encountered had they gotten essentially farther into the property. In other words, you're not going to file a lawsuit over every individual barrier. Once you file the lawsuit, all of the barriers that relate to your disability come into play. And the idea here is the broad remedial purpose of the ADA, the concept that, okay, an individual encounters a barrier. I mean, this might be even, looking back on it, not quite how it ended up working, but a person encounters a barrier, they file the lawsuit. Now the business is aware of it. The business addresses all the barriers, issue resolved. The world is made a more accessible place. That's the idea. That's the idea. But part of the concept too is that individuals can be testers, that they can basically go to various businesses and evaluate their accessibility and take the law essentially, a more active role in enforcement. And that's resulted in, I think, a judicial, permissiveness that tester plaintiffs. On one side of the aisle, you would call them serial plaintiffs. On the other side of the aisle, you would call them tester plaintiffs. It's all a matter of wording, right? Allowing them to basically go out into the world and file these claims en masse. I don't think that the folks that passed the ADA would have anticipated the number of cases that folks file. We're seeing people file dozens, maybe even hundreds of cases. I don't think they would have thought that, but that's the world we're living in now.
Yeah, and I love John's history lesson, right? Because I think a lot of companies come to this for the first time when they get a claim, and they almost like say, well, but why didn't this person come to us first, right? Mm-hmm. Well, one is they don't have to. Two, they know that they'll get better results if they make a claim, right? And three, I think we're going to get into it a little bit. And I think John's point about there are no damages, right? So there are only two things that are going to happen. There's going to be if you say, "Hey, sorry, we didn't know," you're going to have to say, "I'm going to remediate the site," and you're going to have to pay the legal fees. So really, this brings us into, these 4,000 claims are going on, but we see in the numbers that about 95% of these settle within 6 months. They normally settle very quickly. So I really want John to sort of take us into that in a little bit of detail about why are these cases settle so quickly and in such big percentage wise, and primarily our view is that they settle in favor of the plaintiff, not in favor of the company, and to give us the reasons why that is, John.
Sure. So the legal process, the litigation process, is a lengthy one. It is an expensive one. It is one that has embedded risk. You don't know any lawyer who tells you, and I'm going to speak to the potential clients out there, right? Any lawyer who tells you, I can guarantee you a 90% chance of success with respect to anything. It doesn't have to be the ADA, right? 90% chance this motion gets granted. You have to look at that lawyer askew, because there's just much more uncertainty built into the process that, than to allow you to give that sort of estimate. And the joke among a lot of lawyers is like, everything's a coin flip, and I've had clients say to me, like, ask me for an assessment and say, don't say it's a coin flip. And these are lawyer clients, right? Because they know the joke, 50-50, right? Everything's a 50-50. So there's uncertainty and there's cost, there's legal fees, there's filing fees, right? And then there's time. And then there's also distraction. A litigation process, we talked about it earlier, starts with the filing of a complaint. But then if it goes into discovery, it results in the exchange of documents, evaluating the documents for legal privilege, for relevance. Then they proceed to depositions. You ask a witness questions on the record that's transcribed, similar to the way that this presentation is being transcribed by our captioner. And then you have the phase where you can ask the judge to, grant one way or the other before a trial. It's called summary judgment. And then after that, there's a trial. And after that, there's appeals. And then after that, there could be more appeals. So it's a long process. And so what businesses do is they evaluate what the cost of that and the uncertainty of that process is going to be vis-a-vis what an early resolution would cost. And the reality is that for this 90% number, the settlement dynamic, the settlement metric is going to be more favorable for an early resolution than going the distance. There's other factors too, and you see that here in the bullet points. Legal uncertainty. Jason pointed out earlier that the WCAG is not incorporated into ADA Title III. That's true. If you look at the number of courts that have evaluated the question, for example, of whether a business without a physical presence, without a brick and mortar location, is subject to the ADA, whether the ADA covers online-only businesses. If you look at the way courts have evaluated that very discrete question across the country, you will find varying answers to that question. Should the business have a physical place? Should there be a nexus or a connection? Should the website inhibit the access to that physical location? Or is the inclusion of the word place in the ADA something that needs to be broadly interpreted, consistent with the broad remedial purpose of the statute? And should we just say, listen, any digital place is going to be a place? Well, the answers are all over the map. And that's just one question. We haven't gotten into how the WCAG and the ADA sort of combine and work together, or what the exceptions should be, the impact on small business, whether things are technically infeasible. All these questions are unanswered in the case law. So there's a lot of uncertainty. The WCAG is hard. It's why you need a company like UsableNet to help you, or another company, right? It's hard. So that's another aspect of it as well. The defenses can be a toss-up, again, the 50-50. And the cost and complexity of conformance. Oftentimes, businesses will say, I'd rather take ownership over the remediation than turning it over to, potentially a court if we were to have an unfavorable outcome. And then the remedies or the consequences if you lose, which is complying with the court order. If you lose, it's you need to fix this. Paying your legal fees, a guy like me, paying the plaintiff's legal fees if they prevail, a civil penalty if the action is brought by DOJ, and damages if the case asserts state law claims that provide for damages. Remember, the ADA doesn't provide for damages, but in places like California and New York, there are local requirements that impose damages. And then, of course, reputational harm. If you're a company that holds yourself out as a DE&I leader and you've been sued for an inaccessible website, is that a good look? So I think those are the reasons why companies settle, Jason.
Yeah, and I mean, just to paraphrase that, and I also start on the first one, right? The first one is that a vast majority of digital properties out there have barriers because it hasn't been given, accessibility hasn't been given the priority as much as other things, in very busy teams with business goals, and maybe accessibility has to, take a back seat in terms of, faster delivery and stuff like that. So there's lots of practical reasons why websites might have accessibility barriers. Not, the team didn't decide to put accessibility barriers in, but they essentially ended up with accessibility barriers. So, unfortunately, you could make an argument. These cases have been going on for 20 plus years. Companies haven't given it the priority of trying to remove these barriers. And it's very easy for plaintiffs and plaintiffs firms to find barriers, document them, and put them into a claim. As John says, now you've got a decision of, do we spend lots of money arguing over how much work we've done? Is this really a barrier? There's a list of 100 things. How many are real? How many are not real? Or do we agree that actually, if we all stop work right now and agree, well, the legal fees can only be up until today. They can't be more. So this is the practical reason I think John's talking about, where you could fight, but both legal fees are going to go up, or you can accept it and settle as quickly as possible and take control over the remediation, as John indicated. I think there's the next slide also I think is important, because Going back to John's point about demand letters, you shouldn't just ignore them. Going back to the point that 90% of these are filed by particular law firms. John's going to talk about the three types of plaintiffs and how your reaction to the claim might be different based on the types of plaintiff or plaintiff firm. And that's also, an advert for why I think you want to include someone like John or others who have got lots of experience with these cases, negotiate with these 10 plaintiff firms on a regular basis, understand the process and what they're really trying to get out of it. But I think there's other types which are important to understand that maybe you need to treat differently, John.
Absolutely. So, for the first bullet point, we're talking about the type of plaintiff as being a serial filer or a tester, right? And when I talk about these sorts of plaintiffs, I want to actually go back to what we talked about earlier about this shift that Usable and others in the space are identifying from federal to state court and explain why that's happening. And mainly that's happening with serial filers or testers, okay? So let's just talk a little bit about federal versus state court. Federal courts in the United States are courts of what we call limited jurisdiction. And this actually is in the US Constitution. When the Constitution established the federal court system effectively, it limited them to addressing cases or controversies. And I'm not going to get into the sort of legal, the legal maneuvering around that. But a case or a controversy relating to, for example, a federal statute like the ADA, what we call federal question jurisdiction. And so federal courts are limited in what they are permitted to hear and answer and address. The rest of the claims have to go to state court. And so, even if you have an ADA claim that's asserted in a federal case, that doesn't necessarily mean the court has jurisdiction over it, because of the language in the US Constitution of limiting federal courts to a case or a controversy. How that's been interpreted means you have to have an injury in fact, okay? It also means that if you're going to have the court order something in the future, an injunction, there has to be an imminent likelihood of future harm. So even with an ADA Title III claim, the plaintiff has the burden to show that, number one, I was injured in fact, and that if the court doesn't address these barriers, I will be injured in the future. This is also known as the concept of standing. Now, it's not the same in state court, but it is that in federal court. So what's happened is that federal judges have looked at serial litigants, not always, but some of them have looked at them and said, okay, I have this complaint and you've sued every art gallery, or there's been you've had all these wineries that have been sued, right? Or there's the number of cases that have been filed by this serial plaintiff, and the types of businesses that have been targeted or at least been sued. And then the question becomes then, is this actually an injury in fact? And are you likely to go back to the site after the injunction is issued? Okay, so this question of legal standing is an important one. And I think that it is the number one reason why we're seeing a shift from federal to state court filings. Because I think federal judges are asking the question more today than perhaps they were in 2018. I will tell you, in 2018, 2019, I work at New York City, and I had to appear for a conference in front of the judge in a website accessibility case. And I walked into the courthouse in Manhattan, which is the busiest federal courthouse, I believe, in the United States. And I looked, and it was like a Tuesday, and I looked on the board where they had all the cases, and I recognized all the plaintiffs because they were all the tester plaintiffs who I knew. And I realized that in that morning, in the most busiest federal court in the United States, every case was an ADA Title III case. And I remember thinking to myself, this can't last forever. And so I think that the judges have been more, in some jurisdictions, have been more sort of insistent that standing be shown. And I think that's why we're seeing the shift where those questions in state court are not going to be asked. The other thing to remember too is that the state courts where these cases are being filed are very busy courthouses, like LA County Superior Court, New York County Superior Court, New York County Supreme Court, which is the trial court level in New York. They're really busy places, and they won't necessarily get a lot of judicial attention out of the gate. And so I think that explains it too, in terms of, all right, you're going to file a lot of cases. Do you really want that judicial oversight? If the goal is settlement, right? If you're filing these cases to get a quick settlement, maybe you want to be in a place like that. Okay, so that's like serial filer world. And then when we're talking about advocacy groups, it's different. We're talking about DOJ, it's different because there's a much smaller number of cases that are filed. The settlement parameters are different. I think that settlements with advocacy groups are going to, be less transactional in terms of the dollars. And it's going to be much more about sort of the structure of the program. Oftentimes advocacy groups will require that the settlement be made public, whereas serial claims are usually confidential. And they will have oftentimes more meat to them in terms of what the business has to do. I've talked for a lot though, so let me stop, Jason. I don't want to bore everyone.
Yeah, I'd also say that I'll do some broad brush here, right? Advocacy groups and DOJ typically will be focused on an activity that they think has significantly improved the lives of people with disabilities, whether that's healthcare, whether that's banking, finance, education. Then they're not suing somebody who runs a shoe store. If you are in the world of significant enablement of our general economy, you run you're a healthcare, you're financial, you're educational, you're probably more likely to get a lawsuit from an advocacy group than you are from a serial plaintiff. Serial plaintiffs are looking for ways for them to easily establish, as John said, standing across lots of websites. So, if I went to shop online for a pair of shoes, I can argue to the judge, I had a barrier, each one that I tried, and I tried 10 and they all gave me barriers. And if they fix these barriers, I'll go back and buy a pair of shoes, which is John's point about there's an imminent possibility that I'm going to go back and have harm again, right? So, those are the things that you should be thinking about if you're a company. Is like, where am I most likely to potentially have a lawsuit? That's my general impression of those. I think we also wanted to move on just because I'm aware of time, and briefly talk about a big question that's come up recently. Obviously, is administrations coming back into power that were in power in 2016 to 2018, which was a very significant time in terms of the changes, in terms of the activity level of the DOJ and Title III in particular. I don't know if, John, if you want to talk about that just as a prelude about why, changes in administration can have very serious effect in terms of, areas of law like this, and then maybe just give a sort of case study of, well, what happened in that time in a particular space, but probably we can extrapolate that out into the more commercial space, but just to give people an idea of how does the DOJ and other organizations work in different periods of administration.
Yeah, this is really important. This is the question that a lot of folks are asking, right? So we have Trump 2, administration 2, what is going to happen? You have all these appointments that are being set up, a lot of questions being raised about an anti-regulation type agenda. What's going to happen with civil rights? So this is a question that's really, really timely that we gave some careful thought to before today's presentation. So just by way of a case study, we looked at federal consent decrees. So these are, public settlements between the Department of Education and colleges and universities. And we compared the complaint resolutions, the terms of the resolutions. We compared them under the Obama and the Trump administration. Now, to point out, these cases were already filed in mass by the time Trump took office the first time, and they had to be basically resolved. But what you see on the slide here is basically a summary of the terms. These settlements that were resolved during the Obama administration, they involved using WCAG as a benchmark. There was hiring a consultant and auditor, having a specific audit commitment, having a new content plan, developing a remedial corrective action plan, doing training, having policies and procedures, and having prompt agency reporting. These were all the things that were a component of the Obama era settlements that colleges and universities entered into. Under the Trump administration, again, the cases were pending, had to be dealt with. We still saw resolutions, but the terms were different. There was sort of a looser language around the WCAG. There wasn't necessarily kind of firm protocol requirements or auditing requirements. There wasn't necessarily a training requirement in every case. There was a complaint mechanism required. And there was sort of looser language around reporting. Okay, but the cases were resolved and WCAG was incorporated in the resolution agreements. What this tells you, what this tells us, is that under the Trump administration, the covered entities had more bargaining power, had more leverage, and that really is, I think, the lesson of what we're going to be seeing in the next 4 years. We saw almost no activity from the Trump DOJ on website accessibility under ADA Title III. We didn't see any rulemaking. Enforcement activity was way down. I'm not saying that people weren't filing complaints, but they weren't necessarily maturing into investigations. I think that's a safe bet for the next 4 years, that you're not going to see website accessibility regulations under ADA Title III. But I think, what the takeaway of the last 4 years was that businesses may have the opportunity to, if they have an investigation, negotiate more favorable terms with the agency representatives. You could have full-blown consent decrees that need to be approved by offices of political appointees at Main Justice in DC. But you could also have more informal resolutions, like a letter of resolution, which may not need to be escalated to the Trump appointee who may have a problem with the terms. So what we might see is investigations that are resolved more informally, maybe in a more business-friendly way, candidly, possible. But we don't know, right? We don't know what the next 4 years.
I think, John,
yeah.
If I could inject, because
Sure.
I think maybe there's something here that you want to clarify, right? This is almost indicating, how does the DOJ and other organizations work under an administration that says we need to be more business friendly, right? We need to be more streamlined, less demanding on businesses, right? Because what you're describing here is sort of like how the DOJ or other federal departments, right, negotiated hard in the Obama world, but negotiated less hard in the Trump world.
Right.
But I think the most important number to the individual, let's say, companies out there, is that pre-Trump, there was the advocacy world, the plaintiffs were hoping that the DOJ were going to basically include websites and rulemaking on websites as part of ADA Title III. When Trump came in, obviously all of that work halted. And if you look at a graph of how many lawsuits were filed in 2016 compared to how many were filed in 2017, 18, 19, and 20, the graph is a Everest of an upswing, right?
Yeah. Yeah.
Because if you're from, and the only anecdotal thing I can say there is that one is the lack of DOJ involvement after 2016 opened up a gray area for plaintiff firms to take advantage of, but also plaintiffs, as you said, took themselves into their own hands and became their own AGs under the used in the ADA. And it's likely that the vast majority of potential plaintiffs will feel embodied again because the federal government is not working for them to go out and work for themselves to change the digital world, which will be using the ADA and state laws.
Yeah, I mean,
what's your thoughts on that in terms of, that's my sort of like take on what happens when you take away federal activity and leave it in the hands of personal?
Well, I think you're dead on. And if we can go to the next slide, I think it shows it. You're dead on correct about that. Really, it was 2016. It was really, right, it was 2017, the middle of the Trump era, that we saw the spike in private filings. And so it would be a mistake to take this political development and say, well, all right, I'm not gonna worry about my website anymore. Like I'm gonna spend the money elsewhere. I think that's a mistake. And the reason why is because there's going to be another administration in 4 years, obviously. These activities to make websites accessible is a long-term game. All right, it's not like you could do it quickly, and there is a momentum factor. But the other piece of it, I think, which Jason, I think, articulately pointed out, is that there are going to be more advocacy people looking at this and saying, all right, if the DOJ isn't going to enforce, we're going to enforce, right? And so you could have more advocacy, and I think probably will see more advocacy based lawsuits. You have there already is regulatory momentum that is built up that's not necessarily easy to redirect or reverse. You have under ADA Title II, which applies to state and local governments, you have now regulations requiring WCAG 2.1 conformance. And the effective date is in a few years. And what we're seeing is that embedded in procurement contracts with state and local governments and the federal government is much stronger emphasis on representations and warranties that the providers of digital content affirmatively say that their content is going to be WCAG conformant. So that is something we're seeing. And so even though ADA Title II doesn't directly regulate private businesses, the pressure's on. And then also, the question is going to be in the more progressive jurisdictions, are we going to see, similar to what's been proposed in California, really expansive, stringent digital accessibility requirements like what's being proposed in California, which is not the law yet, but could be a model for other jurisdictions that say, hey, wait a minute, I'm not going to stand by and allow these rights to be put into stasis, and I'm going to take up the cost. And then what does that mean, right? What does that mean for businesses too? So look, I mean, I think WCAG is all signs point to WCAG, for better or for worse. And so it may be worthwhile to stay the course from a business standpoint.
I just put that. I mean, I'll also just called out the first line on this slide, which is the European and Canadian laws and European laws, and what we're seeing in that space, especially around clients, right, is that and it's a little bit to John's point, is like, if you have to support something in one area, you should probably support it in every area, right? So the EU's a little bit more expansive than Title II. It essentially addresses any companies that provide things to government as well. So if you're Dell Computers and you're selling to an EU country, then Dell has to worry about its website in that country and making sure that it complies with the new EU laws. I think one thing to just and we've got a lot of content on this, it's not one EU law where you can be sued by one law in EU court. It's 27 laws which have been generated off of the EU directive. So actually, potentially, if you've got barriers on your website, you can be sued in. You can be sued in Ireland, in Germany, in France, in Italy, all at the same time, all by different jurisdictions and different processes. So but to John's point, if you go out there and uniformly support WCAG 2.1 AA, you're most likely safe in all of those jurisdictions. So unsafe in 27 jurisdictions or safe in 27 is sort of the choice there. And again, it's sort of like the noose is closing in. You know, again, Title II doesn't affect corporations, but pretty much every SaaS-based company in the world needs to sell to local and state governments, and that's going to be in their procurement requirements. So again, you've got to start thinking about this stuff if you want to sell stuff to state and federal governments, or you want to sell stuff in Europe. So you know, it's all roads, as John says, are leading to the WCAG as a way of ensuring that you can do business and you reduce your risk. So quickly on that, John, I wanted to go into our live slide of sort of like the things that you tell your clients that they should do to avoid risk, but also to benefit from the business side of it.
Right. So all of these bullet points, right, are all intended to get to the same place, right, which is to have a usable, workable, barrier-free screen reader experience. If for a blind or a person with a visual disability who uses a screen reader, or a captioned experience, or an experience that works well with assistive technologies with folks that have physical disabilities that impact their ability to navigate through a mouse or through a keyboard or what have you. You know, look. Does this become a more fertile space for advocacy groups? In California, there is a certified class, nationwide class of blind individuals in the Fashion Nova case. In the Northern District of California Federal Court, there is a certified class of individuals, and that case is proceeding. You know, you could have cases that are, you know, litigated through discovery more by advocacy firms. Okay, if you look at the limited number of cases that we have on the merits, and there's about 6 or 7 of them, ultimately, most of them were decided in favor of the plaintiff. And in almost all cases, what the discovery showed was this: people couldn't do stuff. They couldn't make a reservation for a restaurant. They couldn't order a pizza online in the Domino's case. Right? They couldn't navigate and do basic things. So don't think that just because the WCAG is hard and complex and voluminous, that, you know, that somehow takes away from what we're really talking about with the ADA is equivalent access and barrier-free access to the products and services of businesses. So, do you have a website that works well with a screen reader? Can you do the things that sighted people, for example, are there to do? Or can you not, right? And what are the steps to get you to that place where you have a really good, workable, usable, defensible website? That's the goal. And I think that's going to be the goal, you know, through the next 4 years and beyond.
Yeah, thanks, Joe. I really love these sessions with you because I felt like we learn a lot in an intellectual way, but also, you know, what's happening on the ground and what's really happening in these cases. I did want to make sure we stop here and do a Q&A.
Yeah, sure. You know, I think the first question and even the second question get to sort of things we hear a lot from our clients in terms of, well, why isn't the business entitled to sort of a heads up or prior notice before a lawsuit is filed? It's a great question, and it's a great point. The ADA has been, there's been discussion about amending the ADA for at least 15 years to require just that people, before filing a lawsuit, would need to then notify the business and provide them a period of time to respond and remediate the issue before going to court. The advocacy community has very strongly opposed that. And their theory is, or their position is, that I shouldn't have to give you notice to enforce my rights. In other words, you shouldn't get a period of time to fix something that should have been right the first time that's creating a barrier to access to me. That has been their position. It has been loud and it has been heard by various sessions of Congress. And that's why we haven't seen traction on that point. But oftentimes in a settlement agreement, you might include that provision saying, look, if you're going to sue me again over stuff, you got to give me an advance notice. You can do that within the boundaries of a contract. The other question is, like, what about alternative methods of reaching out to the business. Like if you contacted a pizza restaurant that had a telephone number, even though the website isn't screen readable, why wouldn't that be enough? That's another great point. And quite frankly, when the DOJ in 2010 was contemplating regulations, that was a question that was put out for public comment. Is having a 24/7 telephone line an acceptable alternative? The courts that have looked at that have said, no, it's not an acceptable alternative, although that's not a uniform view throughout the country, and it's not part of the law. And the argument there has been, well, look at all the things that you're able to do if you're cited, for example, on a website. Look at all the things you can experience and see and interact with. And now, you're basically calling somebody up to have them sort of deliver the same experience. And I think that it really goes to sort of a fundamental disability access point, which is the sensitivity around asking for help. People with disabilities don't want to ask for help because people without disabilities don't have to ask for help. They can access the goods and services independently. And that question, independent access, is a fraught one, I think. But I also understand the questioner and the frustration. All right, wait, hold on. What is this going to cost me? How much is this going to cost me? And can I stay in business? I think that's a question that is problematic when we talk about what the cost of this might be. What I would say is you got to look at sort of quick, easy wins. What can we do to make the site more usable, even if it's not, perfectly WCAG conformant? When I have a client that has a good website, even if there's an automated scan that says there are errors and, flags and all that nonsense. But I have a good website and I have a company like Usable that's saying like, okay, like we looked at it with a screen reader and you can get to where you want to go. Like I use that, right? I call the advocate up and I say, hey, this is a good website, and there may be ways to get there that don't cost, a prohibitively large amount of money.
I'd also say, John, one of the things I always put on the top of the list of what a company should do is they should check their contracts with anybody they're paying to build their website, maintain their website, add functionality to their website. Inject and enforce that you expect that you're paying money for something and they're the technical experts and they should be making sure that the website or the functionality that you're using of theirs is accessible and conforming. That is should be a costless activity in terms of if you do it at the right time in the right place. And that will get you at least into a better position. One step further is asking for, regular annual or biannual reports to show that it's accessible. Again, giving someone like John evidence that activity has been done. And I love John's, we do this for all of our clients, and we do this, even as a service for some clients. Is we have a group of assistive users who use screen readers on a daily basis for their own lives. That they go and try and do the top 5 or 6 things that a website's expected to do, and if they do it, we record it. We make reference. That's evidence that actually, our users could do it. That helps with any client that wants to, again, give something to John to negotiate. If they can't do it, even if you've not got a lawsuit, that is motivation to go fix something. That is people trying to do things and can't do it. I think that's more motivating to go fix than a list of issues found in the WCAG.
Precisely right. It really comes down to, I think, usability. I think that the way this is playing out is sort of unfortunate because, there are so many questions about how the WCAG is going to work for small businesses. And I do believe, there should be some allowance made based on cost. It's very difficult to do that through the courts. I'm a litigator and I've done this for 20 years and this is my profession and I'm proud of my profession and I'm passionate about it, which hopefully you got on this presentation. But, this is really a policy issue. Like we need to establish the rules. People need to comment on it and be a part of the process. Having the problem with the courts is they can only deal with the facts before them. We really need sort of policy. But in the absence of that, then I think we have to do the best we can. And I think the best we can is looking at this at a human level and saying, if my neighbor came to me and said, I went on my website and I'm low vision and I couldn't see these things because of the color schemes that you used and my magnification software didn't work. Like, if your neighbor said that, you probably would say, oh my gosh, I'm so sorry. Think about it that way, as opposed to now I gotta address 5,000 flags from an automated scan, and just think about it on a human level. When you do that, I think you equip your counsel, your lawyers, your defense attorneys to really advocate for you, whatever, however the case may be. On the other hand, our marketing agency builds an ADA compliant website, but some clients don't sign on for a maintenance agreement. Once we hand over the site over, the client is able to make changes on their own and most likely not accessible. As the original developer, and we're located in California, do we need to worry about protecting ourselves? If so, how? Well, it's a great question. This gets to the real challenges of this and disentangling this. Yeah, you have a developer that builds a good website, but who has content privileges on the user side, right? And so you could have a good website that then is made, replete with barriers by the user because the user isn't trained properly. That's why in the prior slide we talked about sort of training and having a program. The original developer, it's really going to come down to the contract and who's responsible for what. I think that the purchasers need to have appropriate expectations for their developers, but the developers also need to have honest conversations and appropriate contractual protections so that their responsibility is limited to what they're producing, and kind of getting into that in the contract in terms of who's responsible for what is a critical task. But it goes to the point of there are many different hands, there are many different sources of this inaccessible content or potentially inaccessible content. And so you can't wave a magic wand and just make everything perfect. It's a complex issue, but one that I think that over time we can solve.
And that ends today's webinar.